Now we shall talk about the mediation and conciliation panel, which is very innovative feature that has been introduced in this particular act, and we have section 442 for this. With effect from 1st April 2014, the central government has been empowered to maintain a panel of experts to be called as the Mediation and Conciliation Panel for mediation between the parties during the pendency of any proceeding before the central government or the tribunal or the appellate tribunal. So this feature, I believe, is going to help in the expeditious disposal of the cases. Any of the parties to the proceeding may apply for referring the matter pertaining to such proceeding to the Mediation and Conciliation Panel while the proceedings before the central government or the tribunal or the appellate tribunal are pending. The central government or the tribunal or the appellate tribunal before which any proceeding is pending may suo motu refer any matter. Suo motu means on its own. Refer any matter pertaining to such proceeding to this particular mediation and conciliation panel. Section 442, subsection 3 provides for it. The mediation and conciliation panel that will follow the prescribed procedure and dispose of the matter refer to it within a period of 3 months from the date with reference and forward its recommendation to the central government or to the tribunal or to the appellate tribunal. What if any party is aggrieved by the recommendation of this particular panel? Then for that also we have this. Any party aggrieved by the recommendation of the mediation and conciliation panel may file objection to the central government or to the tribunal or to the appellate tribunal. We have the provision for company prosecutors also. This is again a very fresh provision which has been provided here. The central government may appoint company prosecutors for the conduct of prosecutions arising out of this act. The company prosecutor shall have all the powers and privileges conferred to the public prosecutors appointed under the Code of Criminal Procedure. Section 443 provides for it. It may also direct any company prosecutor to present an appeal from an order of acquittal passed by any court other than a high court. Section 444 provides for it. Let me tell you about the compensation for accusation without reasonable cause. Section 445 provides that the provision of section 250 of the CRPC shall be applicable with the necessary changes, what we call as mutatis mutandis, to compensation for accusation without reasonable cause before the special court or the court of session. Now we are going to talk about the application of fines. As provided under section 446, the court imposing any fine may direct that the whole or any part of it is to be applied towards payment of 1. Cost of proceedings or a reward to the person on whose information the proceedings were instituted. This provision corresponds to section 626 of the previous act. Now I'll tell you about the recent notification. 18th May 2016, the central government has notified that existing courts in the state of Maharashtra, Jammu and Kashmir, Goa, Gujarat, Madhya Pradesh, West Bengal and Union Territory of Andaman and Nicobar Islands and Dadra and Nagar Haveli and Daman and Diu have been designated as special courts for the purpose of trying offences under the Companies Act 2013. As per these notifications, these courts have been designated for the purposes of trial of offences punishable under the Companies Act 2013 with imprisonment of 2 years or more. Now, we shall talk about the learning outcomes. Whatever we have learnt about the Constitution, powers and the duties and the procedure which is to be followed by these special courts. The learning outcome would be learning about the establishment of these special courts, which is an innovative thing which has been introduced, and I believe this is going to be a very bring changes as far as the disposal of the cases as well as the pendency of the cases is concerned. Then we shall understand about the constitution, powers and duties of these special courts and the offences which are to be tried by these courts. Then we have learnt about the mediation and the conciliation panel of the experts which is to be maintained by the central government. Then we have learnt about the prescribed procedure for compounding of the offences, compensation and appeal under the Companies Act and the latest notifications in this regard. Let us try to summarize the important things which we have learnt in this module. In this module, the legal framework of establishment of the special courts, their constitution, their powers, their duties, as has been prescribed under the new Companies Act 2013 has been dealt with briefly, though we tried to put in as many detail as possible. And we have learnt about the different provisions under Chapter 27 of the Act, the offences triable by such courts, and then what is the procedure which is going to be followed if somebody, any stakeholder or any of the parties is to go to the appeal or review, and transitional provisions that has been discussed. Further, we have learnt about the compounding of certain offences and the related provisions that has been stated briefly. The central government's power has also been talked about to maintain the panel of mediation and conciliation experts and appoint company prosecutors. And at the end, we have learnt about the provisions relating to compensation and fines that has been provided. Thank you very much. I hope you have been learning about these special courts interestingly. I wish you all the best for your exams and your successful completion of the modules and the outcomes. And if you have any questions or queries, you can reach me out on the online portal.